The long-arm jurisdiction of the Unified Patent Court, introduced to the Brussels regulation, gives the UPC jurisdiction over defendants domiciled outside the EU for acts of patent infringement committed within the territories covered by the court. It also introduces the power, subject to a number of limitations, for the UPC to award damages arising from infringement of a European patent in certain jurisdiction outside the EU. In other words, the UPC can concern itself with acts of infringement of a European patent in non-EU European Patent Convention countries: Albania, Bosnia, Macedonia, Iceland, Monaco, Montenegro, Norway, Serbia, Switzerland, Turkey, and also the UK. It does not apply, however, against defendants who are domiciled in Lugano Convention states, Iceland, Norway, and Switzerland. As stated in Article 71, where the UPC has jurisdiction in relation to infringement damages over a defendant occurring within the UPC, in subparagraph 2 it may also exercise jurisdiction in relation to damage arising outside the Union from such an infringement. This jurisdiction is subject to the requirement that property belonging to the defendant is located in any member state party to the instrument establishing the UPC, and the dispute has sufficient connection with any such member state. It has been commented that though this jurisdiction is discretionary, the travaux préparatoires make it clear that the words in relation to damage arising outside the Union from such an infringement were intended to refer to the result of an infringement committed outside the territory of the EU, which could be, for example, the UK or Switzerland. Less clear is what this means in practice. For example, does it imply that the UPC could decide on an infringement of a UK patent under English law in order to decide what damages flow from that infringement? These questions will need to be worked out in the context of real cases in the UPC. The requirement for connection to a member state in which there are defendants' assets is also unclear. Would it allow the jurisdiction to apply if defendants has assets in, for instance, Belgium, but the infringement takes place in Italy, and that is also where the defendant is sued? There is more. Article 71 also establishes the jurisdiction of the UPC over non-EU domiciled defendants, which in itself is not unusual for a European court, but it also purports to give the UPC the power to grant a PI or other measures such as a search and a seizure in respect of activity in, again, for example, the UK and Switzerland. The result is in effect a cross-border preliminary injunction against acts committed in the non-EU EPC countries. Patentees and their exclusive licensees will want to explore the potential opportunities provided by the long-arm jurisdiction, where it can enhance a strategy of a one-stop shop enforcement in this new court.